you become the legal title holder of everything, and you take the legal title holder off the state, and the state no longer holds the legal title on anything. Because
that's why incorporating your name is so important, so that you can use it in this next trust.
Yeah, and when you do that, it actually collapses their trust, because they've got no control over the trust.
Well, that's what you want, isn't it? That's part of the idea, isn't it? Park everything away out of their arm's reach. So.
Yeah, so the trust is either collapsed, or you use the trust so that you can use it in their system and be part, and be in their world, but not of it. Like it says in the Bible, I'm in your world, but I'm not of it. And that's what the trust allows you to do, is to control the legal fiction in their world, so that if you want to do anything in their world, then you do it as the trustee of the person, and not the person. So it separates you, so you can be in their world, as the trustee, but not of it.
Yeah. I understand
that. So, it's all a part of coming out of her and staying out of her. So you first of all you come out, and then you've got to unbind yourself from the world. But when you unbind yourself, then you can't operate in the world. So that's why you have the trust and everything, so that you can operate your person, or the person, in the world, but you operate it as the trustee and not as the debtor, or the whatever, they try and the surety for the person, or the whatever they try and make you,
Can we make ourselves the executor of the trust, as in for the legal person, or it has to be the trustee? Because normally when you go to court, they always want to make you the trustee of the. I thought.
Yeah, no, you're both. You're the executor and trustee of the trust.
I see. I see. But what I'm saying is, if they want to slam you for fines and stuff, then it's normally the trustee that ends up being responsible for the trust, isn't it?
Not when the trustee is in the land of the living.
Oh, I see. Okay. Oh, so you'd be right. I get it. So at the moment, they're trying to make us the trustee in their trust, which is incorporated, but we make a trust that's unincorporated, so we're a living trustee, not
that's right.
Not in there. Yeah, that makes sense. That's where I mix things up, because you talk about trustee like it's fine, and then I read other stuff, and it's like you don't want to be the trustee.
Yeah.
But it's in two different jurisdictions.
Yeah, you've got to. You don't want to be a trustee of their trust.
No.
But when it's a natural law trust, or a common law trust, then you want to be the trustee. And it's the trustee virtually just gets to use everything that's in the trust. Right? So he's in the land of the living, and gets to use everything that's in the trust, whether as the trustee, and not as the person.
And so would we make us? So can we be? Would we generally be the beneficiary as well?
No.
Or so we'd be that we could make ourselves the beneficiary, or it's better not to be.
No, the beneficiary. He who benefits bears the burden in their system, right? The beneficiary is the one who bears the burden of everything.
Of the tax, you mean?
Well, yeah, anything. Yeah. In their system.
I thought the beneficiary could only take from the trust. That they're not responsible for anything.
Yeah, but that's you're talking about two different laws. You know, one's Roman law and one's English law. You're mixing.
Yeah, that's what I'm asking.
Yeah, you're mixing the two. You know, you're talking about one. You're talking about one, and what is, you know, like, see, like in contract law, you know, in England, like whenever they try and contract with you, right, they're doing it in Roman, right, and in Roman law they don't have to give you consideration. And as soon as you say, look, I need consideration for that, right, it drags it out of their law into common law, and they have to give you consideration.
I see.
And it's the same with their trusts are different to common law trusts. You know, so when you're talking about a trust, you've got to talk, you know, about the trust that you're talking about. You know, one is an apple and one is an orange. You know.
Yeah, I see.
And
so I should read that. It should describe that in that book, the Weiss book on trust.
Yeah, well, yeah, it is. Yeah,
does it describe the difference of both of them, or it just talks about the common law trust, really? Huh?
Yeah, it's only about the common law trust, but it does tell you the difference between the two. You know.
Oh, right, okay. Yeah, I haven't read it yet. I've read bits, but I haven't had a chance to read it all the way through.
Yeah. No, it's you know, their statutory trusts are in their world, right, and they have authority over the stuff in their world. So we're not in their world, you know. So, you know, you've got to imagine that we're in the world of the living, right? And as a trustee, you know, our office is in the land of the living, and we're virtually driving our person around in their fictional world, you know, of the dead, and we're doing it as a trustee, you know. So whenever we sign contracts or whatever for the person, you either sign it as the executor of contracts for the person, or the trustee for the person, depending on what it is that you're doing, you know.
Okay.
And
can I ask another related to the signing? If we sign stuff, would we sign it the way we would sign normally as a person, or we autograph it as a living being?
You know, you autograph it, and it can be running, writing. All I do is my first name, you know, and all I do is running, writing, so it's readable. Right, so that's an autograph, and not a scribble that is a cursive and curse yourself.
I see. Do we need to unprint each time or not? Or that's only that's only for like posh stuff?
Yeah. It's, you know, when you're contracting, all it is you use by, capital BY, colon, right? So when you use that, it means that you're doing it for someone, right? So capital BY, full colon, that means you're doing it for the person. And then you do, you know, the just your first name, you know, and then comma, executor.
Yeah, I see. Okay.
All right, so
hang on, let me click on that, make it bigger. No? Oh, can't make it big. Oh, you can click the top right corner and swap it anyway. Oh yeah.
Yeah. So by.
Oh yeah.
Executor.
I see. Yeah.
or trustee, depending on what office it is that you want to do it from. Right, so you execute contracts for the person, or you're the trustee of the estate. It depends on which one your office you want to be from. You can use both of them. I use both of them all the time.
I see. Yeah. As long as it's from the common law, it doesn't really matter, I guess. If it was in their trust, probably want to be the executor. But in your trust, you want to be the trustee. Or it doesn't matter.
Yeah, well, it all depends what you're doing. It all depends.
Like I've got,
if it concerns property, then it's generally the trustee that looks after the property, right? Because they're trying to take the property, right, in that name. And you say, well, no, you can't take it because, that name, it doesn't belong to that name. It's in trust.
I see.
So like when you put anything into trust, right, you no longer own anything, right? The trust does.
Yeah.
So they can't take it off you because you don't own anything. The trust owns everything.
That's why they say own nothing, control everything.
Yeah. So you own absolutely nothing except your shirt on your back, and
even that could go in the trust, couldn't it? Really?
Yeah, the trust owns everything. So if they want to try and get anything, if they want to try and get any property, they've got to try and get it out of the trustee. And how do they? They never send anything to me because I'm in the land of the living. They can't subpoena a trustee that's in the land of the living. How are they going to get you to court when you're in the land of the living? So,
it's tricky.
Yeah.
It's tricky, all right. Very tricky.
They try and get around it every way that they can, but at the end of the day, you've got to, just make it known that, that you're the trustee of it, and and that, they've got to recognise that, they've got to recognise the trust because the Australia, the sovereign state, is a signatory to the Trust Hague Convention 1991. And in there it says, that they've got to recognise all the trusts, which is the common law trust. Right? So they've got to recognise the trust and they've got to recognise the jurisdiction of the trust. And the jurisdiction of the trust is made by the settler. And the settler in these trusts has done it according to the King James Bible and the Commonwealth of Australia. So for them to get it into court, they'd have to take it into a Chapter 3 court of the Commonwealth of Australia.
Okay.
That's the only way that they can get it into any court because, they are a signatory to the trust, and it says in there that they've got to recognise the jurisdiction of the trust, right? So when we say, well, it's the common law and equitable courts of the Commonwealth of Australia, then that's a Chapter 3 court under the Constitution. And they're not going to try and, they can't get in there because they're in the world of the dead. And the Chapter 3 courts in the Constitution are in the land of the living. You're muted, Scott.
Oh, okay. I think we don't have any Chapter 3 courts here, do we?
No, that's the point.
No,
How are they going to get?
yeah, I realise that, but I'm just checking that the Supreme Court or one of them wouldn't count. But they don't, I'm guessing. They're all part of their court.
It's all private. They rent the Supreme Courts and whatever, and they run their private bar business courts in there, and if you wanted to get one, use it. Probably the only way that you do it is if we got two justices of the peace, and we went in there and told them that we were required to use the court, and then put them on the bench.
Oh, I see. Yeah, so like make a common law assembly, pretty much.
Yeah, no, he says the courts belong to us. We wouldn't have to rent them. We just have to supply the proper magistrates or the justices. Justice of the peace. Justice of the peace is a magistrate.
So, but they can act for in the living, or they would still be in their jurisdiction.
The justice of the peace is still in the land of the living.
Is it? Okay, I wasn't sure.
Yeah. They've made their own, but it's pretty hard for them to say that, but I've made officers, I've made common law justice of the peace. And what we're going to be doing is we're going to be making people common law justice of the peace. And they'll be under the organic Commonwealth. And so therefore, they'll have authority of the Constitution and common law. So,
what was that convention that you mentioned earlier? You got Hague Convention. Is it the Act on something about the trusts? You said there was something in the Hague Convention that they had to acknowledge all trusts. I was trying to Google it.
Yeah, the Trust Hague Convention Act.
Hague Convention Act.
Yeah, Trust Hague Convention Act, 1991. That's the Australian Act, but the convention was actually in 80 something or other. There was a Hague Convention, Trust and Recognition or something or other.
Oh, I see. So basically, it was decided in the Hague Convention, and then they put it into an act in the Parliament of Australia, or kind of. So this act is this their fictional acts, or these are the Commonwealth Act?
No, it's a treaty.
Right.
So it's recognising a treaty.
So it came. The Hague Convention was a treaty, but it's been enshrined into an act, because they call it an act.
Yeah. So
but who would have wrote the act up? It would have been wrote up here to represent to reflect the treaty. Yeah,
it's written up to say, well, Australia will abide by that treaty because it's a signatory to that treaty, and this is what it will abide by.
Oh, I see. So the act pretty much just copies out the treaty. Oh yeah, I'll download it and I need to keep what we all do, don't we? You turn up anywhere, you need big packs of freaking backup stuff.
Yeah.
I couldn't even take the Constitution to court. They wouldn't even accept that the last time I went.
No, well,
it's quite funny.
It's not their jurisdiction.
No.
They're in the land of the dead, and the Constitution is in the land of the living. They can't see it.
Yeah, that's right. Yeah.
So
same as the other acts.
Yeah, so like you take it in there and they say, oh, can't use that here or whatever else. You say, well, I must be in the wrong jurisdiction then, which is, and therefore it's incompatible with me, am I free to
go? Yeah, pretty much it.
Well,
yeah, so get better. Last time I went in there, I tried to use all that. The judge just looked at me blank. He just pretended he didn't even know what it was.
Yeah.
I was pretty much arguing with the judge in front of the whole courtroom. Not arguing, but I was like, so you're a judge, you've served for how many years? And then told me how many years. And I said, you don't know what the Australian Constitution is. And he just looked at me blankly. And I'm like, well, you're either lying to my face or you're not fit to be a judge, really.
Not the Australian Constitution, it's the Commonwealth of Australia Constitution.
Well, the Commonwealth. Well, I had the right date, the right thing, because I had it in my hand and I was reading it out.
Yeah,
and I had to take it. I had to take it up to the bench and show him. He just looked at it and just pretended he'd never recognised it before. And I took up the what's that thing that the National Measurement Act? That's pretty common. But that's also a Commonwealth Act, isn't it?
Yeah.
And they didn't recognise that either.
Yeah.
So
weights
a bit of fun.
Weights and measurements.
Yeah, weights and measurements. Yeah, national measurements and weights, whatever it is.
Yeah.
So yeah, I took that in there as well, and I didn't. That was from that Aussie speeding tickets. The thing is, they tell you all this stuff to do. They just forget to tell you that a court's not going to recognise it. So then you go into the court looking like a freaking dickhead. If they pre-warned you, the court's not going to accept it, because then you can actually know what to say when you go into court.
Yeah.
So as it was, I just had a bit of fun with the court and a bit of fun with the police. Had the courtroom laughing. Got a few handshakes, but I still lost my bloody case. I had to appeal it again. But at least I got some experience and a fine.
Yeah.
Fun. It reduces my stress level. Next time I go to court, I'm a bit less apprehensive about the thing, which is good.
I don't go into court and argue law. Right? I go in there and I go in there and I tell them, look, you are trying to deny me my rights, and I want my rights. And that's the only thing I go in on is rights. You're trying to deny me procedural fairness. You're trying to deny me my right to if they're after a debt or something or other, to verify the debt, or if they're trying to get me on whatever, find what right it is that they're trying to deny you. It's got to be, they're going to be trying to deny one or two rights, and you just go on the right. Look, you're denying me my right to be able to do this.
What's the best? When you say, obviously we have rights, but obviously if you mention rights in court, they'll be like, what rights? Where would we just get that from the Bill of Rights, or are we just talking about inalienable rights that we just assume because we're human?
The natural rights, the natural law rights, and it's a maxim of law that he who doesn't stand on his rights has none. Right?
Yeah, I heard that.
Yeah. So if you don't exercise your rights, then you have none. And that's what you're doing when you're going into court. You exercise your rights. Right? You're trying to deny me my rights. I want my rights. And you don't go anywhere except for, I want my rights. You can't deny me my rights.
Yeah.
And, if it's the jurisdiction or whatever, you say, well, I don't believe that I'm in the right jurisdiction. You're denying me my right to proper jurisdiction. This court is incompatible with me. Am I free to go?
Yeah. I'm going to have to practice this one.
Yeah. If it's if they're trying to deny you a right, you've got to stand on your rights and demand your rights. And it doesn't matter what they say, you just keep bringing it back. No, that would harm me, and that would be, that would be harming me, and by harming me, you're treading on my rights to being safe, and secure. And your office, you would be exceeding any authority of your office, because no office has a right to harm anybody, and therefore you would be doing it privately, because because you're doing it privately, then you'd be privately liable, and I'll sue the arse off you.
This would be to the judge, generally.
To anybody who's going to try and harm you, copper, the judge, or anybody else. If they're going to exceed the authority of their office, then they're doing it in the private. And you say, look, your office does not have the authority to harm me, and if you do harm me, I'm going to hold you privately liable.
Yeah, right.
All right. The things we don't know.
I found one. I just pasted something I found in the chat from the aph.gov website. It's all right for people like us that don't know our rights to claim them.
Yeah.
It's quite funny, actually. This is from the Parliament of Australia, and it clearly lays out like the Bill of Rights, common law, constitutional monarchy, due process. It's got corpus, habeas corpus, Magna Carta. If you mention any of these things to police or the courts, they'll just look at you with a blank look, and it's on their own freaking website.
Yeah.
Quite amusing. Pardon?
Yeah. Like
presumption of innocence. Oh yeah.
Like
good luck with that in their fucking courts.
Well, if you don't demand it, you won't get it. You have a right to be presumed innocent until proven guilty, and he who makes the claim has to prove the claim. And if you don't stand on that right, like I've got the right to be presumed innocent until proven guilty. Now, it's up to the one who's making the claim, the prosecutor or the whatever, to prove that to prove his claim. Where's the evidence? If he can't prove it, if he hasn't got any evidence, if it's hearsay, it's inadmissible. Where's the evidence? They're not going to have it. They never do. You just stand on your rights, and your right is that he who makes the claim must prove the claim.
Yeah.
So there's a right there,
That's why I have to keep my mouth shut more often. That's the thing. It's why we always should ask questions, isn't it? Ask for information.
Every time you open your mouth, you're either making a claim or you're asking a question.
Yeah.
Right? So whenever you make a claim, you're the one who's got to prove that claim. So.
That's actually interesting. So when you go into a court and defend something and you say, I wasn't doing this, they can say, prove it, because you said you wasn't doing it. So we should really go in it or not. Is that the case?
Yeah, well, the thing is, you make them say, well, you done this. All right, well, you prove it.
Oh, I see. That's the thing. So if you go in and they say you were speeding and you go in and say, I wasn't speeding, they can say, prove you wasn't speeding. Yeah. Whereas really we should we should just not claim he wasn't speeding and say, no, you proved that I was speeding. I see.
Yeah,
So the fact you even plead not guilty is you're already screwed because you're making a claim that you're not guilty. Obviously, you shouldn't plea anyway, but the fact you plead has made a claim, and now you got to prove that you're not guilty because you pled it.
Yeah, well, you
in a way.
You don't even
I don't know
want to get that far. You know, you don't want to plead anything. You know,
no, exactly.
You want to go in there. You want to go in there and just say that, you know, this court is incompatible with me, you know, because I'm a Commonwealth national, and you know, and this court's incompatible with me.
How does the Crown fit into this? I chatted to someone earlier on Facebook, an older guy who's into law and stuff, and he was talking a lot about. He didn't really talk much about living and non-living. He did a bit, but he was saying you have basically the Crown. The Crown obviously comes from England originally with the Queen and everything, and you got the Crown Corporation. But then it's like he said, the Crown Corporation gives the jurisdiction for the state to make a jurisdiction, and the jurisdiction of the state gives authority for, you know, like court councils and other stuff like that to make jurisdiction. But he was saying when we have our person, you have a legal. I don't know if this is true. This is what he said. You have a person and a legal person. So he said your person is basically comes under the Crown directly, under like federal, I guess, but under the Crown. Yeah. And then he said your legal person comes, you know, under their jurisdiction, under the public. So he said what happens in the court when you go in there and you basically say you're the first name or the first and second name, but you're not the surname. That's their person, or that's the Crown property. So you basically said you can still stay under the Crown jurisdiction, but you don't want to move under their public jurisdiction. Because he said they're kind of separate, so they're still like two jurisdictions, but they're trying to take you in like this jurisdiction and put it onto this side. Yeah, it's not about higher or lower. They kind of run parallel to each other. And he said as soon as you go into the court, they try and flick you to statutory law instead of. He didn't say common law. He just said under the Crown, because this was like under Catholic law. Yeah, no. Your name as a proper noun is proper English, and is under common law. You know, it's under the Crown. And when they bastardize it in any way by capitalizing it or whatever, then it's under their jurisdiction. You know, they're trying to get you into their jurisdiction by using the bastardized name, right? So if you use the bastardized name, they own the bastardized name, right? So you'd be committing fraud for trying to use their bastardized name. So basically, like normally my name would just be Scott, but when we're talking about all this stuff, I put it as Scott Russell, so it would like hyphened, and then but obviously in the court they would want to call me either Mr. Hope or Scott Hope or Scott Russell Hope. So most of the time we'd have to just say, you know, that's the legal fiction. Or I'm not the legal fiction. I'm the trustee of a trust which resembles that name, basically. But I guess it's different now because we've created this trust. Once we create the trust, it's a little bit different, I guess. But even without the trust, we'd have to. Well, when you go into court now, you say I'm the executor of contracts by that name. You know, so when they call the name, it doesn't matter what they call it. You know, if they say, oh, you know, Scott Hope, whatever, you know, and you say, yeah, I'm present on that matter, and they say, oh, you know, are you Scott Hope? You say, well, that's the name that I contract for. So what are they going to say? Yeah, are you Scott Hope? Well, what, don't you understand English? That's the name I contract for. I can't be a name. You can't be a name. A name is a name of a thing. You know, it's what you're called by. You know, so you can say, oh well, yes, that's what people call me. You know, and it's still not saying that you are him. You know, that's what they try and do is get you to say that you are the person.
If you
So
if you
could
say,
we
well,
specifically say we're not, or it's better not to do that?
no, don't make the claim that don't make any claims. Right? You just say, well, that's the name that I contract for.
I see. Okay. So is it wrong? Would it be wrong to say you go by Scott Russell and you're in the Hope family, but you're not called by Scott Hope,
Well, it's
or you choose?
yeah,
Like, I don't identify with that name. I only contract in that name. I
well,
contract on behalf of that name.
they just say, what are you Scott? Are you Scott Hope or aren't you Scott Hope? If you're not
Oh, I
Scott
see.
Hope, then we'll hear it without you being there.
Oh, I see. Yeah.
Are you Scott Hope or not?
Oh, am I? Oh, all right. No, I'm not Scott Hope. I'll
Well,
contract to that name.
if you're not Scott Hope, we'll hear it. We'll hear the case of ex parte. So you're not Scott Hope?
Yeah, it leaves us in a position now, because then they'll just find you guilty and then you're screwed anyway.
Yes.
So what would you say? You just say that you contracted that.
That is the name that I contract by.
Okay. All right. Cool. Okay.
And
Then you didn't claim it.
yeah, you're not claiming the name. You're just claiming that that's the name that you contract by. You know, you're not claiming that you are that name. You're not a thing. You know, their courts are all about res. You have to be a thing to be in their court. And if you're not a thing, then you can't be. You know, the court's incompatible with you. You know, so if you say, well, that's the name that I contract by, you know, then you're not a thing. You're just saying that name is a name, and that's all it is.
I see. Do you would you say, because some of the people that I learned from say, if you go to court, you always go under like special, like a special appearance. So you'd pre-write to the court with whatever you had in process, like affidavits and that stuff. So maybe send them in and say, you don't belong in that court, or you just say the matter's been solved out of court. But then if you come to the court, you say you're coming as a special appearance.
No.
Is that correct, or it's not? Because obviously we hear a lot of different things from different places.
Getting that far, I'd be saying that name is the name that I contract for.
Yeah. Okay. So there's no. That's what I'm saying. There's no, because I've been told to say that we're here under special appearance, because you're not appearing under their court. You're appearing because you have no choice, because they've summoned you.
Appearing is the spirit appearing. You should be present for a start. Because
you don't want to be appearing. So you want to be present. Yeah.
Appears in front of them as the spirit, like the judge or the magistrate or whatever are there talking to the dead, because their world is the land of the dead, right?
Yeah.
And you appear there as a spirit, right? And you're talking to the judge as a spirit, as the dead, right? But when you say something like, when he summons you, right, or when he walks into the room and they say, all rise, and they all rise up. That's the rising of the dead.
Yeah.
Right? And so all the dead are in there, and he's talking to all the dead. And the only way you can do it is say that you are not that name. You are not a thing. So you just say, look, I'm the one who contracts by that name. And if they say anything other than that, what you say, well, don't you understand English? I just told you, that's the name that I contract by. I can't be a name. People call me by a name, but I can't be a name. I'm not a thing.
Mm-hmm. I see.
So
Okay.
put the onus on them to talk properly.
What about the whole standard rising thing? Because that was another thing I've heard before. When you if they say all rise, when you're following their orders, kind of without debate, it kind of means that you're dropping into their jurisdiction.
Yeah, that's right.
But then if you don't, you get done for contempt.
If the judge says, "Oh, go and sit over there. We haven't got time for you at the moment," and then you go and sit over there, then you're under their jurisdiction. You do
They'd
anything.
have to say, "I'd rather stay here."
Do anything that they say, then you're obeying their orders, and so you become under their jurisdiction. We're known by our actions, right? So if they tell us to do something and we do it, you're obeying. You're being a good little slave and doing what they say.
Yeah. So what should we do? Just say, we can't say no because it's dishonour, isn't it?
I turn me back on it.
Oh, so you just do the dishonourable thing, fuck it.
Yeah.
Basically.
Yeah, I just turn me back on them and then turn back around and start talking again. Just don't do.
Oh, I see. Just pretend you didn't hear it.
Yeah, don't do whatever they say, or you can say, "No, I'll waive that offer, thank you."
Oh, I see. Yeah. Writing notes. Otherwise, I forget. I have to imprint these things in my brain because my brain shrinks to about 2% when you're under stress.
Yeah.
Total shift.
Interesting, man.
Total shift. It's a total shift in the way you think. That's what I'm finding. A total shift, like a shift, a move.
Shift.
Oh yeah.
Shift.
Yeah, it's a shift. It's shifting consciousness about. We've all been indoctrinated that we've all got to think this way, and it's completely opposite to how you should be thinking.
Mm-hmm.
You got to have a total mind shift out of what they want you to do into what you should be doing, and that is living in the land of the living and knowing who they are and who you are, and staying in the land of the living and not entering into their dead fictional world.
Mm-hmm.
And demanding your rights.
So this all rise thing, I guess it's better just to not be in the court. Just go in when they just ask them to call you in when you go in, because otherwise you have to stand up and then kind of debate with the judge, don't you? You have to kind of say, "Well,
I usually
Your Honour, I will stand up on condition that."
I usually stand up with my back to the judge until he walks in and sits down and everybody's stood or whatever, and then I wait until everybody sit down, muck around for a little bit, and then take a seat.
Oh, I see. Just so you're not doing it directly when they say it.
Yeah. So I say all rise, you're already standing and you've got the back to the judge. So when he walks in, you're not paying him any respect, because you've got your back to him. And then, they say, "Oh, sit down," and then, you rustle around and get a few papers or whatever, and then, if you're going to sit down, then you sit down after that, but you don't do it immediately when they say, "Oh, sit."
So there's no risk of this whole dishonour thing until they've got jurisdiction. It doesn't matter about the dishonour to an extent.
The whole honour and dishonour thing is about contract, and that is the offer and whatever else. They don't have any honour. They are deceitful. They are dishonest. They lie. They cheat. They do any. They do not have any honour whatsoever. The only honour they are talking about is in contract, and that is when somebody makes an offer, you've got to accept it, or you've got to make a counter offer. That's the only way to stay in honour, and that is the only thing in honour that they are talking about. They
Oh
do,
yeah, I get that. Yeah, yeah.
they
I get
do
that.
not
So
have honour. That is the only honour that they are talking about, and you in theirs, they say that you have to accept it, or you've got to make a counter offer, right? But there's also another one, right? Is if they make you an offer and you say, well, I'll require consideration for that. It takes it out of their jurisdiction and brings it into common law. And then they've got, whatever the offer is, they've got to give you consideration for it.
I see.
Which moves it out into, yeah, wow. That's far out. It's just, God.
Hi, Anita. Hello, Anita. Anyway, yeah. So, yeah, there is no honour in. They have no honour. They lie. They cheat. They are the most dishonourable people there is.
Scumbags.
There is no righteousness in their world. So when they talk about honour, all it is contracting, and that contracting is that they say to keep in honour, you've got to accept the contract, or you've got to make a counter offer, right? But there is also a third one, because in English law, right? In English law, you have to give consideration for every contract, right? They're doing it under Roman law. And so what you say is, well, they make an offer, you say, well, I would require consideration for that. And it drags it straight away out of being Roman law into being common law. And you're now negotiating a common law contract, which requires that both parties have equal value. So if he says, I'm going to send you to jail for a week, say, well, I'd need consideration for that, right? And then it's how much consideration would he have to give you to throw you into jail for a week? He would have to pay you. You say it's $200,000 a day for each day that you want to throw me in jail as consideration.
Yeah, not too bad a deal, I guess.
Yeah.
Do some pull-ups, bit of weight training.
Yeah. Go for a week holiday and earn $1,400,000.
Yeah, I'd ask him to put me away for a month. At least I could go and meet all the common law people in the courts.
Yeah.
They wouldn't be very good if they're in the jail, though, would they? They might just be hanging out for a bit as well.
Yeah. But yeah, like everything in their world is contract. But as soon as you mention you require consideration, it drags it out of being Roman law into English contract law, and he's got to give you consideration, and you hold him to that. You say, well, where's the consideration? You're contracting, because then he's going to be in dishonour.
So what if they just swear and shout at you? You just have to repeat the same thing back.
Yeah.
Because in reality, they won't just say, "Oh, okay, then that's fine." They'll just scream and shout and say, "I'm going to do you for contempt. Shut up, sit down," and they'll try and get you back in there.
Well, I'd require more consideration for that.
Okay.
They're going to every time they say anything to you, well, I'd need consideration for that. And that consideration, I'd need $1 million for that one.
So we can require a set amount, or we can just ask them to offer a consideration.
So what are you gonna give in equal value? Are you going to come to prison with me? Are you going to come to jail with me for a week?
I heard that one. What's that maxim? All equal before law, we're all equal, or something, or we're all equal at law. Or no, I think before law, we're all equal. So when the judge tries to send you for like a mental assessment or something, some guy, a guy I know, said that the judge said to him he was trying to make him have a psychiatric evaluation, but like, being of two minds and all this stuff. So he said, sure, but before we're all equal before the law, so how about we both go do it together? And the judge was like, fuck.
I've said the same to a judge. He said he was trying to get me to do it, and I said, look, I'll accept your offer, to have a evaluation if you have one, and you explain to the site, that you are in here and you're talking to the dead.
Yeah.
That's good. I like that.
Yeah.
Definitely.
And
I'm writing that down.
And so, but the best thing to do is to go into their courts for a start, and if you do go in, you only go in to tell them that the jurisdiction is incompatible with you. Because you are a national of the Commonwealth of Australia, and the jurisdiction is incompatible, and are you free to go, or are you being detained?
Yeah.
Free to go.
Under common law, as in for a crime. Basically. So you'd say you're being detained under common law. Then if not, they can't really detain you under their law.
No, that's right. So if you're not being detained, then they're free to go, and they'd have to say, well, you're free to go because they can't detain you anyway because it's the wrong jurisdiction.
I see. And they can't hear the case. They can't just hear the case in your absence. Or because you're saying you're there, but you're just not accepting the jurisdiction.
No, he would have to say, well, if you go or whatever, you will hear it after. He can't just say, well, am I free to go? And then say, yeah, you're free to go, and then hear the case.
Yeah, I see.
You would have to say, well, if you go, we're going to hear the case. And then you say, well, how do you believe that I'm not here? Can't you see me? You think are you here talking to the dead, and you can't see the living or something? Yeah,
and remind him about the psychiatric treatment.
Yeah. You're not here talking to the dead, are you?
I think we need to have some regular Zoom meetings, and we can practice comedian lessons. we can all practice these things, and it'd be good if we could video in the court, wouldn't it? We could just have like live bloody comedy shows. We post them on Facebook every week, like the Aussie Cossack, like he does with the police. We should just do that with the courts.
He's they're all going to courts, you don't want to go into them anyway, but the thing is, don't argue law, just stand up for your rights and tell them that you're in the wrong jurisdiction.
Simple.
Incompatible, the jurisdiction's incompatible, their court is incompatible, because you're living, and they can only talk to the dead.
it must freak a few of them out, though, the first time they come across this thing, these judges, when people stand up to them.
Yeah.
Must freak them out.
Yeah.
I've had a couple of magistrates go steaming off the bench.
Yeah.
I just didn't know what to do about it when they went, because it's the first time I really stood up to them, and then I was questioning. I can't remember what I was doing now. I was questioning something about the Constitution and all this stuff, and then she just went all flustered, started stamping around, and then stormed out off the bench, and then she wouldn't come back. I was just stood there. I was like, oh yeah. But I didn't like, if I'd known, you can do that whole thing, can't you? If the judge leaves the bench, you can, say a load of stuff. But I didn't know what I was doing, so I just stood there. Then someone else come back, and then they just tried to get jurisdiction. I didn't really know how to follow through with any of the stuff.
Yeah.
But as soon as she heard me talking about the Constitution and rights and the previous paperwork I had, she was just like, screw that, see you later. I was quite proud of myself. I didn't do anything. Not proud of myself, but I was like, you see it happen with other people, but you don't really expect it to happen so easily. And then when it happens, you're like, oh. So, it just shows you how dodgy they are. Do you know what I mean? They're pretty highly strung. Doesn't take much for them to freak out.
Yeah.
They're not. I mean, half the judges aren't exactly powerful people. Half of them are just sleazy little pricks, to be honest with you, from what I've seen anyway. They just sit there with their little freaking hammer outside the courtroom. They're just pathetic little people. Do you know what I mean?
Yeah.
Not all of them, but half of them.
The best way to get them, like everything in their court, is about contract, right? They're trying to contract with you, and if you can be a better contractor than them, then you've got them, And I done that when I went in as the executor, and what I did first of all, I said, I'm there under duress, because if you're not there under duress, then you're there freely and under their jurisdiction. Then I said, I come in peace, because if you're not there in peace, you're there as a belligerent. And then I said, I've come here today I'm present today as the occupant of the office of executor. So you've got to be present and not appearing, because you're not there in spirit. You're there you're there. And I said that I've come as the executor for the estate, and
execute them.
Yeah, the executor of contracts for the person. And then said, I'm present today to help settle this matter in peace. Do you accept that? Right. So I made an offer. I made an offer to the judge. Right. The offer was, I'm here in peace. To help. Right. I was there to help. And to settle the matter, right? So I was there to settle the matter in peace and to help do that, And I made them the offer, right? So when I make them the offer, they've got the choice of either accepting that offer or making a counter offer, right? And so to stay in honour, they have to do that, right? And so when I said that, she went, oh, and then I said, do you accept that? And she goes, oh, yes, I do, because she couldn't come up with it. She wasn't expecting it, and she couldn't come up with a counter offer in time, But if she had have said no, then she would have been in dishonour. And she would have also been belligerent because I said, I come in peace.
Yeah. She's shutting you down. So if they shut you down and start yelling.
Yeah, she would have been a belligerent in dishonour if she had not accepted my offer. Right? And I could have said to her, well, you're being belligerent and dishonourable. And she probably would never have got on the bench again, because you cannot be a belligerent and dishonourable and be on the bench.
Yeah. How could you enforce that stuff? Just
be on
because if they're taking,
all the people there would witness that they were being belligerent.
So you'd call on the people in the court, not so much on the clerk of the court and all them people.
Subpoena them and say, well, okay, this guy's being belligerent to me and whatever else. Did you see that? Ooh. And you subpoena who was ever in there.
I see.
So, that's how I done it in that case. Is I was better at contracting than what they were. Because I used peace and help, and I've come here in peace to help, and so when in their system, if they don't accept the offer, they're in dishonour. And she couldn't come up with a counter offer, so she would have been in dishonour, and plus she would have been belligerent because I said I've come in peace to do it, and by not accepting that offer in peace, then she's been belligerent.
Yeah.
Yeah.